Okay. First of all, I would like to welcome all the senior persons out here, Shri Ravi Kanji, Shri Ma'am Dr. Jyotsna Yagnik, my dear Karthik, my dear Manish, my dear Digvijay. It is a great pleasure today to welcome all of you, and we have with us today Dr. Shri Ravi Chadha-ji, who is a very senior advocate and been a lot of cases to his name, fame. He is one of the pillars of Delhi High Court, I must say. We have Dr. Jyotsna Yagnik. She herself was a judge, though their introduction will be by Karthik. Karthik will be welcoming them. Meanwhile, we are waiting for Honorable Justice Iqbal Ansari Sahab. He will join us within a minute. Then we will formally start it. So that's how. And today we are going to talk about such an important aspect of our constitution, the aspect which is, which gives an ability to everyone to do what he pleases to do. Liberty, freedom, as we call it. So the constitution guarantees many freedoms. We all are well aware of it. Constitution gives lot of scope to each one. Citizens have been given lot of part 3s, dedicated part 3s there. And we all know as to how these freedoms from equality, freedom of speech and expression, freedom of religion, freedom, but first of all, the most fundamental of all is right to life. That is also one of the freedoms. And Supreme Court time and again in its various judgments have stated that it is not only the freedom, it is not only the right to life, it is right to life with a dignity. And that right is extended to the extent that it is even right to die is covered. Right to dignified death is also covered in it. Such a beautiful explanation by our own Supreme Court. Now, I would request my dear colleague who has joined us from Bombay, a very new lawyer, part of BSK Legal team. And I know him since the days when he was interning with us. And now he himself is a full-fledged lawyer. Of course, now he's, going to join this stream. I would request Karthik to welcome Adarniya Shri Ravi ji, Ravi Kanji, Jyotsna ji, and then we will wait for Sir within a minute. I think Sir will be joining. Then after that, you can introduce him also, and then we will initiate our program.
Thank you, Mr. Sanjay sir. I was initially going to introduce all of you guys, but Mr. Sanjay sir has introduced me, and honestly, I'm not liable for any introduction because I'm no one in comparison to you.
I welcome Adarniya Honorable Justice Iqbal Ahmed Ansari from core of my heart, and with this, I would also introduce the panel. Justice Ansari, Dr. Jyotsna Yagnik is a former judge and sitting Pro-Vice Chancellor of Adams University. Respected Ravi Chadha-ji, and I am Sanjay. So we are here for you, sir, and we have just begun, and I would request Karthik to begin the show for today.
Thank you, Mr. Sanjay sir. All right, so good evening, everyone. I welcome each and every one of you for today's session presented by BSK Legal. BSK Legal is one of India's leading law firms, which has an all-India presence through its alliances with local councils from different locations from all the states and union territories of India. Being a full-service law firm, BSK Legal is capable of providing legal services on all aspects of clients' businesses. We at BSK Legal are proud to organize this webinar on liberty the constitutional perspective. For today's session, we have with us 4 guests. I would first like to introduce Justice Iqbal Ahmed Ansari. Justice Iqbal Ahmed Ansari is the incumbent chairperson of Punjab State Human Rights Commission and the former Chief Justice of Patna High Court. He has also served as an executive chairman of State Legal Services Authority in Arunachal Pradesh and Nagaland, and has accordingly performed the duty of legal awareness. We are honored to have with you on board with us, sir. I would now like to introduce Mr. Ravi Chadha. Mr. Ravi Chadha is a highly reputed senior lawyer and eminent jurist of international fame and has been practicing in the High Court of Delhi, Honorable Supreme Court of India, and various other high courts of India for the past 45 years. He has handled matters of fame for the government of India in corporate sector, civil sector, criminal sector, arbitration matters of national and international level. It is great having with us, sir. We also have with us our very own Mr. Sanjay K. Chadha. Sanjay sir is the founding and managing partner of the BSK Legal and is also practicing as a Supreme Court advocate. Under his supervision, at present, the firm is successfully handling cases over 614 districts throughout India. He's also renowned and well-established face in various media channels. It's always great to have with you with us, sir. And our 4th guest for the session is Dr. Jyotsna Yagnik. Dr. Jyotsna Yagnik is a former CBI judge, a TADA and a POTA judge. She is also the former principal of Law College and has been teaching law for almost 34 years in various institutions. It is wonderful to have with us, ma'am. I would now like to pass the welcome our guests.
Honorable Mr. Justice Ansari, former Chief Justice Patna High Court. While saying that, you can see a big smile on my face. It is for the reason that when Honorable Dr. Justice J.N. Bhatt took over as Chief Justice of Patna High Court, I had an occasion to accompany his Lordship from Gujarat High Court, since his Lordship was hailing from Gujarat High Court. So when I read the name of his Lordship, quickly came a beautiful picture of Patna High Court in front of my eyes. Lovely, sir. Lovely to have you over here. Over and above this, I have heard lot about your Lordship. Your Lordship has known a very distinguished dignitary in the country. And since you are looking after human rights, a subject very dear to my heart, and that is the other reason, moreover, the reason that you are going to speak on a very beautiful subject today. I extend my very cordial welcome to you for and on behalf of BSK Legal as well as Adams University, more particularly School of Law and Justice. We have also with us Learned Counsel, Mr. Chadha, as well as my dear friend, Learned Advocate, Mr. S.K. Chadha. So I would say Chadhas are there, and they are going to give us many glimpses of many things. I am lucky to have Mr. S.K. Chadha as a partner in institution in many programs, many webinars, and I've always seen he is master in making the programs, in finding out the subject, in designing the way in which the program will go on. So I'm more than confident that we are going to have a wonderful evening today. We have with us about 7,000 students in different channels with us, and we are also welcoming all of them because speakers are there, but the beauty of speaker is when there are listeners. So we have with us listener today, who all of them are future lawyers or future judges. They all are law students. So we welcome them all. While saying the last line about Adams University, is one of the most popular university in Eastern India, which is having so many awards. That is e-teaching award we have recently got, PR award we have recently got, and today morning we were enlightened with ET Leading Educational Group Award. It is having 11 different schools and international schools also, and different schools is for UG teaching, there is PG teaching, there is PhD teaching. So we have right from KG to PhD. With this, I once more extend my all the welcome to all the office bearer of BSK Legal, all my dear students, and all the students of other organizations. With this, I express my gratitude to Mr. S.K. Chadha to have given me this wonderful opportunity to speak with all the distinguished dignitaries over here. Thank you so much, and we are waiting for the speech.
Thank you very much, Dr. Jyotsna, for your always encouraging words. I know you since past so many years.
I would
Today,
now like to invite Sanjay sir to speak a few words.
thank you. One more thing I would like to say, in addition to what Dr. Yagnik has said, Justice Ansari, that we have got a lot of lawyers have also joined us. So it's a mix of lawyers. Of course, dominatingly, we have got the students pan India. All across the country, we have got students, and at least 20 law colleges have given their students the instructions to attend this webinar. Without taking much of time, I would just like to introduce the subject, which I will take 2 to 3 minutes, and then I would request Sri Ravi Kanji to speak about. And then we all are waiting for you to address the gathering. Liberty, the constitutional perspective. What Constitution says, that is what is the topic today. Basically, liberty, I feel, it is an ability to do what one can do, what one pleases to do. This is what I feel. Freedom is the right word. In the modern politics, modern legal system, liberty means the state of being free. State of being free with the society from all kind of controls, oppressive restrictions imposed by the government authority on what one's way of life, behavior, what to preach, what is the practical things, politically, non-politically, religious restrictions, if that kind of. So that is what broadly is there in our constitution. And our constitution, very specifically from preamble to all the part 3 is very, very relevant if we talk about liberty. The ambit of liberty is very, very wide. What are the constitutional safeguards? What are the constitutional values qua liberty? That is what we are going to hear from our 2 eminent guests today. Without wasting much of time, I would request Adaniya Shri Ravi Kanji to take up and address the gathering. Thank you very much.
Thank you, Sanjay, and the Honorable Justice Ansari ji, and Madam also. You see, basically, we are on this a very good subject. And to me, it's one of the most important organs of our Indian Constitution, wherein the word liberty is there. And now we have to say about what is liberty as a constitutional perspective. The liberty word, which is, as you already said, it is contained in the very beginning. The beginning liberty word is there, and which says that every citizen of this country, wherein the one word is liberty is mentioned, that word is that to secure to all citizens liberty of thought, expression, belief, faith, and worship. These are the words which are there. Now, if we take this and then straight away go to the Article 21, because you will find in our Constitution that the first word liberty is used over here in the preamble, and then we go straight away to the Article 21 of our Indian Constitution. That you will find that the word liberty is the life or personal liberty. Now, I would make emphasis on the word personal liberty. Before taking that word, may I say, and that is history, that it goes back to the history. Now, the French motto was there. Now, if we have gone to or we see the Liberty Islands in the New York, there is a statue of liberty. That statue itself signifies, because by the French liberals, they gifted this statue of liberty to the Americans, and say, because they said that the revolution was based on this, that the monarchy and the system which was there, they wanted to have a free system where the democracy was there. Now, taking into that, they gave this statue, and the light torch which the Statue of Liberty is having, that torch is the freedom path showing for the liberty. Now, if that is so, that those American words in their constitution, we also find in the Article 21. In Article 21, if we go to the Article 21, the words are that our constitution is based on the same principle. Now, as far as the liberty is concerned, in our country, the liberty is the foremost thing. But here, I would like to emphasize and say that the liberty is not the only thing under Article 21, which is the guarantee by our Indian Constitution. This liberty is also dependent upon the Article 14 and Article 19, and Article 19 1D, wherein the free movement is there. And Article 14 with regard to the equality of laws and my protection under the laws. And the basic thing which the liberty emphasizes, that I would like to say over here, that it is, if we go back in the beginning, in the years 1950, when A.K. Gopalan's matter was there, the majority was due, because the Article 21 also says this is subject to the law prescribed, because the liberty is not that anybody can enjoy the liberty, but it is also subject to the laws, wherein it was ultimately in the Menka Gandhi's matter, it was held that no, it is the law should be as such that it should not affect the liberty. The principle of the natural justice should be there. And if law suffer from any vice, then it under the judicial review, it should be struck down. Then it also says that the law should not be unfair or unreasonable. Because if those laws are unfair and unreasonable, that is going to affect the liberty of a person. Now, saying so, that one more thing, that if the law violates the natural justice, because in Gopalan's case, the view was this, no, there is no question. If law says so, then there is no question of natural justice. But the majority judgment in the Menka Gandhi case held that no, the principle of natural justice is a must to keep the liberty. Now, if we go through that, and then we again come to the question that is my liberty can be hampered. Now, there are so many matters. There are so stringent laws which says that no, that you cannot, terrorist law or any other law, which is very dangerous for country also. then you are confined in a jail. But to that also, subject to the law, that other laws, if the body is in the jail, then he has a right to move. His liberty qua movement cannot be that he cannot be confined to some one place and he can't even move in the jail. So this was. But at the same time, I am also taking one more matter. In Khadak Singh's matter, where this belongs to the UP case, wherein the person was ultimately acquitted, but then they, under the UP regulation, which were in the forts, the police used to go to his house in the night and knock his door and say whether he's over there or not. So then the honorable courts under the judicial review said that no, see, that is also infringes his liberty until unless the regulations or rules are in statutory in nature. Only if the rules or the regulations are statutory in nature, then only that is prescribed under the law, but against subject to the law should not be unfair, the law should not be reasonable, and the principle doesn't void the principle of natural justice. So that is the summary with regard to this aspect of the matter, that what safeguard we have under the Constitution of India. So now taking also the Article 14 and Article 19(1)(d), there also, if somebody wants to go abroad, that his movement can't be stopped until unless he has done something which under the law, the statute, which is subject to these 4-5 conditions applicable under the law, then his liberty can be stopped, or he can't ask, or he can't go to the court, because the ultimate is this, that under the Constitution, whether my the right as a fundamental right under the Article 21, Article 14 or 19 is violative, I can straightaway go to the Honorable Court and get that these my rights are infringed, and the Honorable Court can give me the right. Now, as far as the as I have said, that the other right, liberty, because personal liberty I am saying as per the Article 21. The other right is this: if I can be hauled up under some law, criminal law, then the question becomes of the safety of my liberty, the right which I enjoy under the Constitution of India, that can I get a bail or a jail. So that way, there was one very noted matter is the state, what is the Balchand. In that, the Honorable Supreme Court held that, look here, the jail is an exception, but the bail is a rule. So these are certain safeguards, and which if my fundamental with regard to the liberty are infringed, then I can go for a judicial review. And even certain matters, if the laws are so strict that then the it has further gone as far as the liberty part is concerned, that the freedom, now you can't be handcuffed, or if you are means some action is taken against you, which is violative of the fundamental rights and your liberty, the police can't take. And then applying the principle of natural justice in certain laws, where there are board are set up, that and which until unless the board satisfies that you can be released, then you are in the jail and you can't be put out. So there also the courts have so many times said that firstly the paramount thing for the consideration is your liberty, and then subject to that under what law or country you are hauled up, you are detained. Even in detained, you has also got a right for liberty. If the case, and the courts have gone further, saying that it is not the question that before arrest you can't have your right to liberty negotiated or called for in the courts of any level. The courts are bound to see that any injustice is not done to you. If the honorable court sees and finds that the work you put up is against your liberty, then you are bound to get even before an order that this is again, and the only saying that no, we have not arrested him would not suffice the purpose, because the care put up against you is against the liberty. So, meaning thereby, our protection in the constitution is there, but then again, because the words are such that the life, the right for my life or personal liberty is subject to in accordance with the prescribed laws. So these are the things. Then, as I said, that these are certain things which we, the liberty is, but each and every case has to be seen, weighed according to its own merits or demerits. So then, but safeguards are there, and the courts are now very conscious to take a judicial review of the matters, wherein either to even strike down the law that this law is against. Do you want me to end up? Uh, okay. So these are my views, and now I hand over. Thank you very much.
Thank you very much, sir, for your enlightening, experienced word, as I should say. What the courts, which the case laws you have quoted, all of them are landmark cases. And every day we see in the court of law, see you quoting and other lawyers quoting these judgments from Menaka Gandhi to, starting from Gopalan. All these judgments are landmark as far as the liberty is concerned. Without wasting much of the time, the Honorable Chief Guest for today's evening, Honorable Justice Iqbal Ahmed Ansari, we all are proud of you, sir, and the way you have served the country. That's we are really proud of you, sir, and thank you very much for taking out time today. And I would invite you to address the young blood. The young lawyers are also there, young students are there. We all, we take inspiration from you, sir. Thank you very much, sir.
Mr. Sanjay Kumar Chadha, very lovable person for all of us. Mr. Ravi Chadha, Learned Senior Counsel. Madam Jyotsna Yagnik, Vice Chancellor of a very distinguished university. Mr. Karthik, the students and others who are participating in this kind of a workshop, I would say, a webinar. Ladies and gentlemen, it's indeed a great honor and privilege to be here in the discussion of the word liberty as perceived by the Indian Constitution. without wasting much time, as Mr. Chadha had been saying, I'll pick up the thread from where Mr. Ravi Chadha has left. The Indian Constitution starts with justice, and that justice is of liberty, and continues for better part of the Constitution, guaranteeing every form of remedy for a person whose liberty is abused. What we need to understand very clearly is that ours is a democratic republic. Democratic republic means that the head of the state is an elected body. Otherwise, democracy exists even in United Kingdom, but it is not a republic because the head of the state is not elected. Now, democracy as defined by Abraham Lincoln, which is the most popular definition, means government of the people, for the people, by the people. But what is really the soul or essence of democracy? The essence of democracy, you will agree with me, is that we agree to disagree. That means I give you the right and the liberty to every one of you not to agree with everything that I say or I do. At the same time, you must also have the courtesy to give me the same right of not agreeing with you. So this principle of agreeing, not of disagreeing, is really the soul of the Constitution. And we must at the very threshold understand it very clearly that when a government comes to power, irrespective of the fact as to whether I have voted into power or not, the law that it makes will be binding on each one of us. But that does not mean that the government is free from criticism. And if the government is criticized or the laws made by the government is criticized, then in that event, it does not mean that the person criticizing is anti-national. We have to very clearly understand there is a difference between government and nation. Government will keep changing. There will be one government today, there may be another government tomorrow, but the nation will remain. So my loyalty and my interest has to be in the nation and not necessarily in the government. Second important aspect which we have to keep in mind is that law is never static. It keeps changing. Even when the laws are not amended, the application of law stands changed. I'll give you a very simple example without meaning any disrespect to any medical practitioner. There was a time when the society had immense faith in the integrity of a doctor. His opinion, his diagnosis, his prescription was never questioned, his honesty was never questioned. When such was the faith in the medical practitioners, what was the position of law? The position of law was that if a witness X says that he had seen Y being stabbed to death by X, and the medical practitioner says that I did not find any stab wound. What I found was a blunt injury on the back of the head caused by some heavy blunt weapon. So there is a contradiction between the two. But because of the fact that the society had no reason to doubt the veracity of the evidence of the doctor, that the law was that in case of such a conflict, it is the medical evidence which will prevail. Today, the situation is that when we go to a doctor and he gives a prescription asking for various diagnostic tests to be done, we start wondering, standing in the chamber of the doctor himself, as to how much commission is he going to receive. So the profession has not changed, but our outlook and perception about the doctor has changed. Now, when such is the situation, when we find that the doctors can be as dishonest as anyone else in the society, they can lie as much as anyone in the society. What is the situation of law? The Supreme Court says that medical evidence cannot always be treated as a touchstone for testing the veracity of ocular evidence. That means eyewitnesses' account of an occurrence. And if there is a conflict between the two, the example which I had given, then in that event the court cannot take the easy path of accepting the doctor's view. The Supreme Court says that that becomes the law, that court will have to make an attempt to decide who between the two is telling the truth. And if the court for some reasons come to the decision that the doctor is not telling the truth and it is the eyewitness who is telling the truth, there is no impediment, mind you, there is no impediment in convicting the accused, notwithstanding the fact that the eyewitness's account is contradicted by the doctor. So such a drastic change has taken place in the law, but there is no amendment in the Evidence Act. Evidence Act has remained the same, but because of the fact that our perception has changed, so the law stands changed. So similarly, the journey of humanity in its fight against liberty, or at many times for liberty, is full of this dichotomy. So there is no standard formula. And that is why we must understand that the liberty of a person is not only dear to him, but it is dear to the society as a whole. And that's why the Constitution guarantees it. Because if one man's liberty is violated, there is no reason why another man's liberty will not be violated. And that is why it becomes the duty of everyone in the society, as was done by Americans, that you raise your voice against abuse of liberty. Because if you don't abuse your voice against abuse of liberty, tomorrow when your liberty is abused, nobody will come forward to support you. Now, what Mr. Chadha has correctly pointed out, that we have under Article 21, as you all know, very closely related to liberty, that nobody shall be deprived of his life and liberty, except according to the procedure prescribed by law. The Supreme Court took the view that it is enough to have a law. If there is a law, then that law is good enough. You will be surprised that in this particular case, the Supreme Court referred to a judgment of Bishops of Rochester. It's a very famous judgment of United Kingdom. There the law was that the accused will be thrown into boiling oil. That was the law. And the English court said, yes, the law is, but that is the law which is there, and that is the law under which the accused will be punished. And the Supreme Court of India accepted this proposition. It is only when we came to Menka Gandhi that the Supreme Court came forward, turned its page, and said, no, it is not enough to have a law. That law must be, as Mr. Chadha has been saying, just, fair, and reasonable. So today, it is not enough to have a law. It is also required that the law must satisfy the test of being fair, just, and reasonable. Now, recently, liberty has become a very debatable question because of the famous case of the journalist who had been incarcerated on the ground of abetment to commit suicide. And Justice Chandrachud of the Supreme Court exercised the power under Article 226 for issuing writ of habeas corpus. There is a storm because now it is felt that is it selectively that the Supreme Court is applying the law? Nobody has any grievance if the Supreme Court chooses to exercise its power to secure somebody's liberty. But then it cannot discriminate between X and Y. That is the situation, because that way Riya Chakravarti's case also comes in mind. There were two aspects in this case. One was the alleged use or purchase of drugs, and the other one was the allegation of abetment to commit suicide. Now, which one was the one for which she had been kept incarcerated for about 2 months? Was it because of drugs, or is it because of the fact that the materials were prima facie saying that she had abetted the offense of commission of suicide? This is what the debate is on, and this is what we have to. And another issue which is very important is that, mind you, as far as the habeas corpus is concerned, majority of the judicial opinion is that it cannot be exercised against a judicial order. When Arnab Goswami was remanded to custody by a judicial order, and judicial order is not amenable to a writ of habeas corpus. A writ of habeas corpus will be available only against an executive order. However, in this case, the Supreme Court has held that it will be available even against a judicial order if the judicial order is without jurisdiction or bona fide. If this is the same law which remains, no problem. Then, as Mr. Chadha was trying to point out, that jail and not bail, bail and not jail, that will come true. But if it is selectively used, then obviously the situation has to be considered very, very seriously by those who are interested in law. At this juncture, I recall the prophetic use of words by Nani Palkiwala when he said on the supersession of the judges of the Supreme Court, all of us know about it, which took place somewhere perhaps 74, if I'm not wrong, or 73. He said 1974 is as important a year as the year 1947. 1947 marked the end of a struggle for winning freedom, whereas 1974 marks the beginning of a struggle for preserving that freedom. So, ladies and gentlemen, this is the time This year is a very important year. It is not only because of the COVID situation, but legally also we are standing in such a position of history that we will have to develop a view. I'm not saying a unanimous view because law is one subject where there may not be a unanimous view, but this is where what is required. Very recently, I think day before yesterday, we have come across a case where a lady, while driving a scooter or a scooty, collided against the vehicle of a police officer. And the police officer was so enraged that he shot the lady point blank. Now the question is, from where has he got the authority? That authority basically is in his head because he considers himself to be the law. And this position will become more rampant. Please take care of it. If the courts do not come forward to check or secure the liberty of the individuals. We all know in Andhra Pradesh, I think 4 or 5 accused who had been alleged to have committed rape were shot dead in an encounter. And when the media person asked a female member of parliament, what is your view? She says in Hindi, देर आए दुरुस्त आए, meaning thereby देर से किया लेकिन ठीक काम किया. Is that so? She was not a witness to the incident of rape. She did not know and does not know whether those 5 persons or 4 persons were or were not involved. She was also not a witness to the allegation which the police made that they tried to attack the policeman when they were already handcuffed. It's not very easy to believe. So she did not know that also. So that is why Article 21 says, which Mr. Chadha had been referring to and heavily relying upon, is that no person shall be deprived of his life or liberty except according to the procedure prescribed by law. So procedure prescribed by law has to be respected if the action of the executive has to be upheld. And if this right to privacy is only one of the facets of liberty. So many the human rights which we talk about are also rights of basically liberty. Because what human right is, though this is not the webinar for human right, but this much is essential for us to know that human right is nothing but the right which a person must have in order to live with dignity. So that the liberty to live with dignity is the right. Now, is it recent development? Human rights? Does it depend upon the Universal Declaration of Human Rights by the United Nations? Before that, there was no human right. Imagine the society where we did not have even clothes to wear. We did not clad. In that kind of a society, if a man wanted to outrage the modesty of a woman or commit rape on the woman, could the woman resist? If we believe in the liberty, if we believe in the respect to human dignity, then we must say that yes, even that kind of a society, the woman was free and could have objected. She had that liberty of not succumbing to man's power, meaning thereby that the human rights are not something new, that is also the liberty of an individual to maintain his or her dignity. And that's why the Supreme Court says animal exists, living like an animal is not really the right to life. Right to life means that you have something more than animal existence. I think I have taken a lot of time. I must therefore conclude. But I must, before concluding, offer my very, very sincere thanks and gratitude to Mr. Sanjay Chadha, the spirit behind this webinar, and the distinguished guests who have participated, my student friends, all of them, for the patience which they have shown to me. Thank you very much.
Thank you very much. So kind of you for your encouraging words. The way you have began, and in the beginning you said that constructive criticism of the government is allowed as per the law. You mentioned that law is not static, law is dynamic. You mentioned how beautifully you gave the example of Evidence Act. Then Menaka Gandhi, development in the judgment of Menaka Gandhi, where you have very rightly said that law has to be tested and satisfied, and that the test of just, fair, and reasonable law is must. That is what is, again, these are the steps how the liberty is constituted. Liberty is strong today. The recent incidents, a day before incidents of that police person shooting at that woman whose scooty touched the car, you took that example. You gave example of Priyanka Reddy, that girl who died in Hyderabad. And we saw that how people appreciated, lauded the police persons through distributed sweets for killing those accused. Without any trial, they punished, which was absolutely not permissible as per the Constitution of India. It reminds me, sir, our own law gave right for the trial to Kasab, who was a terrorist. Everybody knew it. It was recorded in the camera. Despite that, we followed the entire free and fair trial. And then after the trial only the conviction was done. What happened in the case of Vikas Dubey, sir? I want to ask this question. And we have to today ask this question. We are not living in the society where we have to say eye for an eye. And if that is the law, that day is not for that when each one of us become blind. So we have to see that this liberty, the liberty which is enshrined in our Constitution, has to be exercised, has to be given this. And this is one of the root of, as you have very rightly said, Justice Ansari, you have very rightly said that this liberty is what makes our democracy strong. Very correct, you have rightly said, sir. It was a very enlightening session, sir. So kind of you for such a nice, in such a nice package you have produced the concept of liberty to all of us in such a nice way, in a very small way. giving the examples of even a day before. That is what is needed. I am getting the messages all across there in YouTube, which is everybody is saying the way Justice Ansari has explained the liberty that's what we have never thought, that this is what liberty means. So kind of you, sir, and we are really grateful to you for taking out time. I know you came by some flight and rushing. You have just taken out time. So kind of you for this time, sir. And we know that, sir, you are at such a position, for the, securing the human right. That's what you are doing. It is commendable, sir. Thank you very much once again, sir. And I would also like to thank Shri Ravi Kanji, Jyotsna ji, and I would now request Karthik to please have a vote of thanks to our distinguishing guests.
Good evening to one and all present here. I am grateful to be delivering the vote of thanks on behalf of BSK Legal today. Taking this opportunity, I would first like to thank Justice Iqbal Ahmed Ansari for taking out his precious time and imparting with us his wise words and thoughts relating to the constitutional perspective of liberty and giving us the much needed knowledge regarding a crucial matter. A wholehearted thanks to you, sir, to join our webinar and sharing with us your time and shedding light on the subject matter, making this webinar a success. Thank you, sir. We are really humbled by your presence with us. Next, I would like to thank Mr. Chadha for being with us today and speaking his heart out and enlightening with us on the topic of liberty and sharing with us your views and the landmark judgments on the said topic. Your words has given us a much broader perspective of liberty than we previously had. I'm certain that we will all put this knowledge to good use. I would also like to extend my gratitude to Dr. Jyotsna for being with us today and helping us make this webinar into a successful one. And last but not least, I would also like to thank our mentor and a well-known advocate, Mr. Sanjay K. Chadha, for organizing this wonderful webinar and inviting Justice Iqbal Ahmed Ansari, sir, Mr. Ravi Chadha, and Dr. Jyotsna, giving us all this amazing opportunity to learn about the constitutional perspective of liberty, and also for sharing with us your knowledge and expertise regarding the said matter. Mr. Sanjay, sir, along with his law firm BSK Legal, have been taking amazing strides in spreading legal awareness among the law students and common people alike on his various social media platforms. Thank you once again, Sanjay, sir, and team BSK Legal for your continuous efforts. We are most grateful. Also, I would like to thank my fellow mates and from colleges all over the universities and nation, and for all our media partners who attended this webinar and helped making it a successful one. With this, we conclude our session. Thank you all.
Thank you very much. Once again, sir, it was really very enlightening. As I rightly said that सूक्ष्म में आपने सारी चीज रख दी. मैं हिंदी में इसलिए कह रहा हूँ क्योंकि आप तो पटना में रहे हैं. इतने से छोटे से उसमें आपने सब कुछ इतनी अच्छे तरीके से व्यक्त किया. It's an honor to have you, sir.
गागर में सागर.
गागर में सागर.
So kind of you, madam.
And such a nice way of delivering, sir. So grateful. Thank you very much. Thank you very much, Ravi Kanji, Chadha ji, and Jyotsna ji. I will now take your permission to close this session, sir.
Thank you.
Thank you, everyone. Thank you.